Good afternoon and good morning to those of you on the West Coast, and good mid-morning to those of you in between the two coasts. Welcome to our seminar today. My name is Ron Taylor. I am a partner in our labor and employment group, and I'm delighted to participate with my colleagues today talking about the latest rule from OSHA, issued last Friday in the midst of the ongoing angst and concern over the continuing pandemic. What we hope to do today is to provide a high-level overview of the emergency temporary standard that OSHA published last Friday, and to try to answer, to the extent that we can, or to at least foretell what the answers might be to the many, many questions that you have, notwithstanding the 260 plus pages of ink that the government has expended in writing this. We're going to try and avoid politics. This rule, unlike most rules that come out of OSHA, butts up closely against public health issues as opposed to mere occupational health issues. And that has been part of the problem. And those issues involve what is the proper involvement of the federal government in trying to control a public health epidemic. It's a difficult question. We're not going to try and address that. We're here today to try and talk about what the rule says and what you can or should do. Although I said there are 262 pages of ink, a lot of questions remain unanswered. This is highlighted by the fact that there have been several court cases initiated already challenging the rule. This morning, we saw that 3 new challenges by organized labor add 3 new circuit courts to the mix, the Second Circuit, the Fourth Circuit, and the Ninth Circuit. And these are perhaps less related to specific concerns about the rule than they are about which court will decide whether or not the rule that OSHA has issued should be sustained or not. This puts employers like you in an unenviable position. Those of you who can think back to the FLSA rule a few years ago that was almost ready to be put in place but scrapped at the last minute know that you expended a lot of energy in some cases for a rule that never became effective. There are some unique similarities here, and what I can say is that notwithstanding all of the pages, the number of unanswered questions and the uncertainty about the fate of the rule leave you in a tough position. But there I go, sounding like, as the old saying goes, a lawyer who gives you a perfectly correct legal answer, but one that doesn't tell you a single thing that you didn't already know. Well, fortunately, you don't have to listen to me today, because I am delighted to have my much more able and much more experienced colleagues in this area. Allison Gottfried is a senior associate at our New York office, and Robin Burrows is a senior associate in our DC office. Allison and Robin in particular, since the pandemic started in March of 2020, have been drivers within our group, which numbers almost 40 attorneys, in maintaining, evaluating, and assessing the various obligations that state, federal, and local authorities have imposed relating to the pandemic and its prevention. So they are, not surprisingly, 2 of the people who were first up to speed on Thursday, actually, after we saw the rule for the first time. At Venable, we pride ourselves on utilizing other experts in adjoining fields whenever we can, and we like to think that we work, and I think we do work collegially. And so I'm also delighted to have Juliana Reno, who is in our New York office. Juliana is the chair of our employee benefits executive group and health practice. And so Juliana will talk a little bit about some of the issues that might arise under ERISA and HIPAA. Our goal, again, is to touch this at a high level and to try and answer your questions. We have a lot of people. We're over 350 people when I saw the count earlier today. And so we anticipate that we'll have some questions. Feel free that if you're not able to have your question answered during the brief amount of time that we have today, that we are keeping track of the questions and we will try to get back to you with an answer. Alternatively, feel free to reach out to me, to Robin, to Allison, to Juliana, or any of the other people in our labor and employment practice group to get your question answered. Like I say, our goal is to provide you with as many answers as we can in a rapidly changing field with all the litigation that's already been ensued. So with that, let me turn to the next slide and talk a little bit how we got to where we are today. Let me provide a little bit of context because the Occupational Safety and Health Act was enacted 50 years ago in 1971 with the broad goal of assuring that every working man and woman in the United States had a safe and healthy workplace. You came to work with 2 arms and 2 legs. The goal was for you to leave alive with 2 arms and 2 legs at the end of the day. Enforcement is through federal OSHA or through a authorized state plan. At this point, there are 22 state plans that regulate private employers. There are 6 states, New York being one of them, that have state plans that only regulate public sector employees. If you were in New York, you would be worried about federal OSHA and not the state OSHA plan if you were a private employer. Importantly, and this has implications for this ETS, state plans are required not to be the same as a federal plan, not the same as federal OSHA, but simply to be at least as effective as. They can be different as long as they're as effective as. They can be more stringent, again, as long as they're effective as. All of you probably know that the rules that OSHA or its state plans have promulgated are enforced through inspections, citations, and penalties. I could go on, but I'm not because that would be the subject of a separate seminar talking about how inspections occur and how citations and penalties are issued. Suffice it to say that penalties can be significant. For the most routine, most common types of citations, penalties can be just under $14,000 per violation. Now, how does OSHA get all these rules that it's going to enforce? Since 1973, the primary rule has been through what's known as notice and comment rulemaking. In the first 2 years of the act, OSHA was authorized to adopt existing rules because the notion was they had been through sufficient public discussion or otherwise gone through notice and comment rulemaking that it didn't violate due process. Since 1973, however, OSHA's had either to go through notice and comment rulemaking or to utilize one of the other mechanisms. Notice and comment rulemaking is very cumbersome and can take literally years for a rule to come through. The emergency temporary standard was designed to recognize that there might be situations in which there was a grave danger requiring immediate action by the government, something that would need to be addressed before notice and comment rulemaking could be accomplished. And consistent with that notion that it requires a grave danger and immediate action, and consistent with the notion that it is an exception to the government's obligation to go through notice and comment rulemaking, that rule requires that the standard be effective only for 6 months. That way, it's a limited intrusion on the typical due process rights for employers. So if there is a grave danger and if immediate action is necessary, then OSHA can issue an emergency temporary standard which will have a limited period of time for effectiveness, but which becomes effective immediately upon publication. That is what we are here to talk about today. That is what was issued on Friday. Christine, if you could go to the next slide. Last thing, and I provided this timeline only to provide context for you. The regulations or the guidance that you may have remembered seeing in March and April and updated in June of 2020 was really a set of rules that OSHA developed around 2010 to deal with infectious diseases. And it has guided the agency through subsequent public health emergencies, SARS, H1N1, the swine flu, for the ensuing 10 years. And initially, OSHA said those rules, that guidance, the existing rules that we have, such as the general duty clause, which is a codification of the common law duty to provide a reasonably safe workplace, and other rules relating to respiratory use, et cetera, would be sufficient to address this concern. And you can see that OSHA advanced that position through the course of at least a couple challenges, one in the DC Circuit in June of last summer, and 2020 that is, and another one for infectious diseases in the Ninth Circuit later in the year last year. This year, following President Biden's executive order in the early spring, OSHA issued an ETS relating to COVID, but it was limited ultimately to healthcare facilities. Following his most recent pronouncement, the path forward in early September, OSHA promulgated, as they were directed to do by the president, a second ETS, which is much broader. Unlike the earlier ETS, this one is not limited to healthcare and instead applies to all employers with more than 100 employees, with some exceptions that we're going to talk to. What's interesting is that you can see that OSHA estimated that the first one would save over the course of 6 months approximately 800 lives, and it anticipates that this rule will save approximately 6,000 unvaccinated workers' lives. That's by way of overview that provides you with some context, and it's significant to understand that because you need to understand how that plays into the legal challenges, whether or not there's a grave hazard, whether or not there's immediate necessity. So let me switch gears and turn it over to Allison, who will talk a little bit about what is it that OSHA says that you need to do to protect these unvaccinated workers from the grave danger posed by COVID. Allison?
Thank you, Ron, and thank you for the introduction. Like Ron said, the purpose of this particular portion of the webinar is to discuss what are your obligations right now under the standard. What do you have to do? What do employees have to do? And how can you prepare for this going forward? So the first and probably most obvious step is you should determine whether or not you are actually covered as an employer under the standard. So the standard applies to employers that have 100 or more employees as of November 5th. And in order to determine if you have the requisite amount of employees, you have to look at all of your employees in all of your locations. So it is a firm-wide or company-wide count. That includes also remote employees, employees who don't work on site, and those who might not actually be covered by the requirements themselves. It also includes part-time, full-time, temporary, and seasonal employees. That 100 number, though, does not include independent contractors, employees that you have on site but are employed by temporary staffing agencies, employees of franchisees, or employees of other employers that may work on your site, particularly kind of in the, for example, in the construction context. And so one of the big questions that we also have is, what about if you're considered a joint employer? And unfortunately, OSHA doesn't really discuss that in much detail. What OSHA says in this standard is you can be responsible if two or more related entities are, two or more related entities are regarded as kind of a single employer, if for OSHA purposes, they handle safety matters as a company. And that's about all it says. You can use other laws and their kind of joint employer tests as the guide mark or as the benchmark for whether or not you want to consider yourself to be a joint employer. But the rule or this, the standard is really not clear as to whether or not OSHA will use that as the benchmark in order to determine if you have a joint employer status and thus are responsible for certain employers on your work site. One of the other things that the standard notes is that essentially once you reach 100 employees, you are covered and you stay covered through the end of the standard. And so what that means is if you don't have 100 employees as of November 5th, but you reach 100 employees 2 weeks later, you are then covered by the standard, have to come into compliance with the standard, and will be covered by the standard through the end of the 6-month period maximum. What that also means is that if you are covered because you have 100 employees as of November 5th, but you then subsequently go under that 100 employee threshold, you are still covered by the standard through the end of the standard period, which again is a maximum of 6 months. The next step, and the important step, is to implement a policy. And the standard is pretty clear as to what kind of content needs to go into the policy. The first is, what are your requirements going to be for vaccination or testing, if that's the option that you choose? What are your exclusions or exemptions, and how are you going to go about defining or analyzing the exemptions? How are you going to collect vaccination status, pay time off for receiving vaccination, how to notify internally if you are positive for COVID-19, and you as an employer will remove any COVID-19 positive employees from the workplace, how to request other records. if you are an unvaccinated individual, how you'll be handling testing and face coverings, disciplinary consequences for failing to abide by the policy, any effective dates and deadlines, what covered employees will be under this policy, and procedures for compliance with and enforcement of the policy. The policy should be distributed to all of your employees. And one of the interesting things about the frequently asked questions about the standard is that it makes it very clear that employers can have different policies for different segments of their workforce, which means that if you have a segment of a workforce that you think lends itself more to having a mandatory vaccination policy only, and a segment of the workforce that you think lends itself more to having a vaccination or a testing policy, you are allowed to create different policies and different requirements for different portions of the workforce. Other things that you are going to want to think about including in the policy is any sort of educational information, and potentially, information for your employees about how to go about testing and how to access testing and local vaccination sites. And the other thing that I want to make sure that we mention is that it should be very clear to not just your employees, but your applicants, to the extent that they will be covered by this policy, that this is the policy of the employer before they apply or while they're applying during the application process. The next thing is to ensure your employees are compliant by January 4th. And what compliance means is you have to make a determination as to whether or not you're going to have a mandatory vaccination policy or a mandatory vaccination and testing policy. If you have a vaccination and testing policy, employees will also have to remember to wear a mask when they're in the workplace. So by January 4th, 2022, all employees will need to be fully vaccinated, or they will have to start to submit to weekly testing. Fully vaccinated means that 2 weeks have passed since employees have received the completed round of their primary vaccination. So either 2 doses or 1 dose, depending on which they choose. The OSHA is very clear that those that are authorized for emergency use are covered, the vaccinations are covered under this, but it does not include any requirements for booster shots as yet. Again, the other option, and if you don't want to have a fully mandatory vaccination policy, is to have a mandatory vaccination or testing policy. So employees can also be tested on a weekly basis if they come into the workplace at least once a week, or at least 7 days before coming into the workplace if they don't come into the workplace at least once a week. So if it's on a purely intermittent basis, as long as their test is no older than 7 days, they're allowed to come into the workplace. Again, they have to wear face coverings when they do. OSHA has made it very clear what kind of tests are available and eligible for under this testing requirement. So the COVID test has to be cleared and approved by the FDA, and that includes for emergency use authorization. It has to be administered with the authorized instructions. And this is, I think this final point is very important. It cannot be both self-administered and self-read unless the reading is observed by the employer or a telehealth provider. And what this means is that you can't accept a home kit or a home self-test that the employee administers, reads, and then just reports the findings to you. It has to be observed or otherwise read by the employer. Employers can also use pool testing. It does make it clear that that's an option for them. And we're going to talk, Juliana will speak in a little bit about kind of the employee benefits implications of doing this testing. But one of the things that if you are going to make, if you're going to choose this option, some of the things that you want to keep in mind is whether or not you are going to be administering the test, or if you're going to partner perhaps with a testing site. The deadline by which employees must submit their testing on a weekly basis, submit the results of the testing on a weekly basis, and whether or not you want to limit the types of tests that they can use, for example, PCR or antigen or at home or anything like that. The next thing is ensuring that you provide appropriate exemptions when they're requested. OSHA, per this standard, says you can be exempt from the vaccination requirement if the vaccination is medically contraindicated, if medical necessity requires a delay in the vaccination, or if you otherwise have to provide a reasonable accommodation for disability or sincerely held religious belief based on federal law. And I want to remind everybody that while that might be what OSHA's standard is, you have to remember that federal law and your state and local laws may also apply. Remember, when you are analyzing exemptions, you want to do this consistently. And one way in order to ensure that is to create forms for these exemptions if you have not done so already. The standard also requires you to provide time off for your employees. And what it says is that you have to provide time off up to 4 hours during working hours for employees to receive the vaccination, and that this time off will be paid at the employee's regular rate of pay. And so what we're actually talking about here is non-exempt employees. Exempt employees will be covered by their weekly salary regardless. For those people who need time off in order to get the vaccine, the standard makes very clear that this cannot be deducted from any other available leave banks, meaning that that 4 hours is in addition to, not concurrent with, any other leave that they might otherwise be entitled to under law or policy. Now, the standard also says that employers are not required to pay for this time if they have to get a vaccination during non-working hours, such as weekends. And we're going to get into that in a little bit, but it's our opinion that that actually is in violation of federal wage and hour law and perhaps state wage and hour law as well. The employers also have to pay for the vaccination itself, although that's typically offered free or run through the employee's health insurance. So the next question is, what do you have to do for side effects from the vaccination, right? An employee gets time off to receive the vaccination, but under the standard, employees must also provide what they label as reasonable time off for people who are experiencing side effects of the vaccination. And OSHA has said reasonable time is about can be 2 days, up to 2 days. Now, that again might be covered or dictated by state and local law. But one of the things that the standard makes clear is that if an employee needs time off to recover because of side effects from the vaccination, that can be deducted from any of their available sick leave or PTO banks. So that can be used concurrently with other available leave. If the employee does not have any leave available, the standard says you still have to give it to them, and you cannot require the employee to go into a negative balance in their bank if they have to take more than the time available to them under this. The next is you have to collect and maintain proof of vaccination and test results. So the standard is also very clear that you have to accept proof of vaccination or proof of a negative test results, and the standard allows for various types of proof of vaccination. But one of the things that's important, and one of the things that may change your practices, is that you have to actually keep a record of this proof of vaccination according to the standard. And what that really means is that this requirement may not be satisfied by an employee merely showing you a picture of their vaccination card. Rather, you have to get a copy of it and maintain it as a record. In addition to getting proof of vaccination or getting a proof of a test result, the standard requires you to keep a roster of employees and their vaccination status. And that's for all employees, whether or not they're fully vaccinated, partially vaccinated, or not vaccinated because they're subject to one of the exemptions. And the standard says all of this information, so the proof of vaccination, the proof of testing, and this employee roster with the vaccination status is considered to be confidential medical information, which is consistent with how the EEOC treats this information based on the Americans with Disabilities Act. And so you have to keep this confidential. And what that means is that you have to maintain it separate from an employee's personnel file and under lock and key. It's got to be, it has to be secure and not easily accessible, with the exception of a few people, typically in your human resources department. And in terms of record keeping, the standard says that all of this information has to be kept through the end of the ETS, so which would be again up to 6 months, which is different than OSHA's typical requirements, which in some cases can require you to keep it up to 30 years. So at this point, it's just a maximum of 6-month requirement. You have to also provide other documentation, which includes the CDC's key things to know about COVID-19 vaccines, any other information about retaliation and discrimination, and information about the laws that provide for criminal penalties if an employee knowingly provides a false statement or documentation to the employer when the employer is collecting these kind of records. And finally, I'm sorry, not finally, next to finally, you have to, employers have to be sure that employees who test positive for COVID-19 promptly notify them, and that they cannot report to work or must be removed from work immediately. And this is already a requirement under many, actually it's already a recommended guidance under the CDC's guidance, but it's also already a requirement under many state and local public health authority guidance. And employees cannot return to work unless they receive a negative confirmation test, if they meet the criteria to return to work pursuant to the CDC's isolation guidelines, or if they meet or if they have a recommendation from a healthcare provider that they can return to work. One thing to note is that the standard itself does not require contact tracing, nor does it require that employees be removed from the workplace if they've been exposed to somebody with COVID-19. But again, check your state and local regulations and guidance for that. One of the things that I just want to say, this is not actually an obligation, but based on all of this, one of the things that I think employers need to be prepared for is for increased turnover in their workforce based on all of these requirements, right? So this might be the law, but there are going to be a lot of employees that aren't happy about it. And so you should be, you should start to, in addition to preparing yourself for how to implement this policy, prepare yourself for worker shortages in a time where you may already be in a difficult position. Next slide, please. Great. Okay. So just some other notable provisions that I think that are important here. Under the standard, employees may have to pay for testing. So the standard does not require employers to pay for any costs that are associated with testing, but it does make clear that you may be required to pay for it under a different law or regulation or pursuant to a collective bargaining agreement. So for example, if the testing is provided as an accommodation because somebody is exempt from the mandatory vaccination policy, the ADA essentially dictates that you pay for that kind of accommodation and pay for that testing. And again, we'll talk a little bit about kind of the ERISA implications for doing so. Another important thing is that the standard is very clear that it establishes a floor and not a ceiling, which means that you are free to implement stricter measures as it relates to any of the requirements in there. And it doesn't actually displace any sort of collectively bargained rights or obligations that exceed the requirements of the standard. So again, you can go further than what the standard says, but it must be at least as strict as what the standard says. Certain employees are not covered by the standard. So those who work in a workplace where they have no other contact with other coworkers or individuals or customers, those who work exclusively remotely, and those who work exclusively outdoors are not covered by this, meaning that they do not have to either be vaccinated or submit to testing if that's part of your policy. Employees who work remotely some of the time, but not all the time, will still need to either show proof of vaccination or test, depending on what your policy says, when they report to the workplace. So it only excludes remote workers that are exclusively remote, that will always be working from home. There are different deadlines for different obligations. So the deadline for everything except for vaccination and testing is 30 days after November 5th. So you have to implement your policy. You have to start collecting vaccination statuses. You have to remove employees from the workplace and some of the other requirements that we talked about. All of that goes into effect as of 30 days after November 5th. No later than 60 days after November 5th, which is the January 4th deadline, employers have to start requesting and requiring testing for employees who are not fully vaccinated. One of the other obligations of the standard is that employers have to report COVID-19 fatalities and hospitalizations to OSHA. So they have to report COVID-19 fatalities to OSHA within 8 hours of learning of them, and work-related COVID-19 inpatient hospitalizations within 24 hours after learning about them. And you should note that again, these have to be work-related incidents, and work-relatedness is in line with existing guidelines that require that the case be the result, at least in part, by an event that occurred in the work environment, which is sometimes very difficult to prove in the COVID-19 situation. And finally, while I hope that you guys find this webinar to be helpful, OSHA has also published some other supplemental documents that are very helpful that can be reviewed, including frequently asked questions, fact sheets for employers and employees, a summary of the standard, template policies that are intended to comply with the standard, and a social media toolkit. And so I want to turn it over to Juliana, but I think that Ron actually will announce the CLE code word.
Yes, so for those of you who are attempting to get CLE credit, the code word is MOOSE, M-O-O-S-E.
Thanks, Allison. Could we have the next slide, please? Thanks. Okay, so I'm going to talk really briefly about the employee benefits implications here. So if your company's strategy is to say to your employees, get vaccinated wherever you want, get tested wherever you want, just show us proof one way or the other. We don't care, we're not paying for it, we're not doing it. If that's your strategy, you can tune out for the next 3 minutes because I'm not talking to you. I'm talking to the companies who are either providing or paying for the vaccination and testing. When you provide or pay for medical care, the arrangement is generally a group health plan subject to ERISA and these other laws that I've got listed on the slide. So the first question that I have been getting from all of my clients is, wait a minute, this is not an employee benefit. This is something that we're doing to comply with OSHA. Unfortunately, there's no rule under ERISA that says if you're doing something just to comply with the law, then you're exempt, it's not a plan. I like the argument, I'm sympathetic to the argument, I just don't have any good law supporting it. So if we're gonna go in and make that argument, you just need to know there's not a lot of backup. It's just a good, sensible argument, just not a lot of stuff supporting it. Okay, the next question I get is, wait a minute, we've been giving flu shots for years. Isn't the vaccination the same thing as a flu shot? Yes, it is. Generally, flu shots are not plans because under the exception that I've got there on the slide, there's no ongoing administrative scheme. The difference is that this standard has a fair amount of record keeping related to the vaccination that may make it different from the flu shot. And it definitely has a lot of record keeping related to the ongoing testing. So I think that this is going to be different than most of your flu shot scenarios. So if you are providing or paying for medical care, you probably have an ERISA plan and you have to do some compliance. So there's two main ways that you can comply. The main problem is that you need to comply with the Affordable Care Act, which says that every ERISA group health plan has to provide all this preventive care unless you qualify as an accepted benefit. So the two easiest ways to qualify as an accepted benefit is to have the vaccination and testing through an on-site clinic or structured as an employee assistance program. There is no definition of an on-site clinic. So could we argue, let's say you decide to have, a mobile van come and do vaccination and testing once a week. Will that be an on-site clinic? I don't know. I would not be embarrassed to make that argument. There's just not a lot of guidance around that. Some employers have on-site clinics. The problem is that's not going to work if you have a very diffuse workforce, right? If you have one office, that is a lot easier. If you have 25 different locations and people are moving all over the place, that's a lot tougher. Employee assistance programs. So most employee assistance programs right now are the arrangements where you say, oh, we'll give you 6 free sessions at a therapist. That's how most employee assistance programs are structured. So you could add this. If you offer that kind of benefit, you could, as a documentation thing, you could just add it to that. But there's a bunch of legal requirements for employee assistance programs. And the main one is, as relevant to this vaccination and testing thing, that the employee cannot be forced to pay for it. Okay? So if you say to people, we'll split the cost of the testing with you, that's going to be a problem. So if you're going to provide the testing, if you're going to provide it on site, right, and it's not even if you're not going to provide it on site, if you're going to pay for it, right, you don't want to pay for half of it. You want to pay for all of it, which means you probably want to make arrangements with a lab or CVS or Walgreens or something like that, so that you don't say, oh, we'll pay for any test you get, because that would be really, really, really expensive in the long run. So that is the main issue. There are secondary concerns. ERISA documentation, have a plan document, report it, all that business. COBRA, you arguably have to offer COBRA for this, although honestly, no one's going to take it, so I'm not super worried about it. And there's Hipaa concerns. There are ways to deal with the Hipaa issues of if the employee, if your rule is the employee has to give us the documentation, then that's not going to be a Hipaa problem. There are other ways around it. None of those are insurmountable. I also don't think that there's going to be a lot of enforcement on those issues, the documentation issues and things like that. I think most of the enforcement is going to be worried about if you make them pay for it, or if you're splitting, if you're violating that, if you're claiming that there's an employee assistance program, but you're making them pay for it. I think that's where the main problem will be. Okay, so I'm done. I'm going to pass it to Robin to talk about the sort of substantive concerns on the actual employment law side. Robin, over to you.
Thanks, Juliana. So thanks, guys. I'm reading the questions as they come in. I think I'm going to hit 2 of them on this slide. So thanks for all your time and these great questions, and for coming out today for what we know is a really confusing bit of material. So Allison has already covered a bit about time off and PTO under the standard, and Juliana was mentioning the benefits issues. I'm going to talk first about some other payment concerns. The first of those is time. Time spent being tested and time spent waiting for results being tested will likely need to be paid if the employee is not exempt, or in other words, if they are eligible for overtime under the Fair Labor Standards Act or other similar state laws, or a collective bargaining agreement might also cover this. That means that if you are sending your employees off-site for testing and telling them, get tested on Saturday, bring your test results by Tuesday, they will need to record that time that they spend going to get tested if they're non-exempt, and you will need to pay them for it, which may push them into overtime. Again, that's if they're eligible for overtime, if they're non-exempt under the FLSA or under a similar state law. So as we're talking about, whether you should adopt a testing portion of your policy as you're looking at this vaccination or testing, that's definitely one thing to consider. How are you going to have employees record that time that they spend getting tested if they're doing it off-site? And how are you going to handle any potential overtime concerns that might arise for those employees? The other cost that Allison and Juliana were both alluding to is the cost of the test itself. We don't have a lot of great guidance from any of the relevant agencies on who should or could be paying for the test itself. OSHA says in their guidance that this standard does not make the employers pay for the test, but other things might. And the one that has kind of jumped to the top of our heads as we're looking at this is if the cost of a test brings an employee below minimum wage, either the federal minimum wage or an applicable state or local minimum wage, that could be a problem if you're making the employee pay for the test. So if your employees are going and getting a $150 PCR test every week, that could become very expensive for them. Not only will they be upset, but it could bring them below the wage threshold required for the minimum wage. It could also bring them under the wage threshold required to maintain an exemption if they're close to that borderline. So you really want to give some thought to what kind of test you're going to require and how you're going to make employees get it. In general, we think it's safer to pay for the cost of testing, even though we know it's no one's favorite thing to do, just because it's so administratively difficult to track some of these time and cost issues. And the major concern here is primarily with non-exempt, often lower wage employees who could be eligible for overtime or who could fall below the minimum wage. One of the questions was, isn't testing still free under government guidelines? Testing is free if you have insurance and you are doing it for a diagnostic reason. It's required to be covered. But a lot of this return to work or kind of repeated testing that workplaces require will not necessarily be covered by insurance. So you can't just expect that your employees will run it through their insurance and get it paid. They may have a cost if insurance denies that claim because it was not diagnostic, which is very possible under the current guidelines, and especially as testing programs are going to become a lot more widespread after this guidance. There are also some states that require reimbursement or payment for necessary business-related expenses. So if you're in one of those states, this is the kind of thing that you would have to pay for your employees because you are requiring it of them. That's something to look into if you're thinking about cost sharing. And then the last thing to consider is that it may be required or at the very most advisable for you to pay for the cost of a required exam or test if your employee has a religious or a disability accommodation. This was another question in the question and answer, whether something is, there are exceptions to this. If the cost is an undue burden, you may be able to push some of that cost back to the employee. But whether something is an undue burden is extremely situation specific. Something that's an undue burden for a small employer for one position might not be undue for a larger employer or in a different position. It's just very situational. Discuss that with your attorney. Feel free to give us a call about that. So you might think about that undue burden framework for those exemptions. But in general, we recommend paying for the cost of those tests, those required tests, if an employee has an approved exemption. So beyond wage payment and test payment issues, there are some other laws or guidance that you need to be thinking about. The two most recent bits of vaccination guidance that have come out have been the Centers for Medicare and Medicaid Services, the CMS, Omnibus COVID-19 Healthcare and Staff Vaccination Rule that came out on the same day as the OSHA guidance, or the Safer Federal Workforce Task Force guidance for federal contractors that came out maybe a month or so ago. These pieces of guidance may apply to you in your workforce. I've kind of highlighted some of the high-level bits of information about them here. If you are covered by one of these rules, you're definitely going to want to look at it a lot more in depth. But I wanted to talk briefly about how they apply in conjunction with the OSHA rule. There's basically a hierarchy that these agencies are looking at right now, where the CMS rule sits sort of at the top. If you're subject to the CMS rule, start with that one first. Next, move down to the federal contractors and subcontractors guidance if you have a federal contract. Then look down to the OSHA rule if you're not covered, or if you have employees that aren't covered by either of those first two. And then any state or local mandates come kind of at the bottom of the pyramid in looking at compliance with these rules. And these rules are important to look at because unlike the OSHA rule, neither the CMS rule or the federal contractors rule allows for testing in lieu of vaccination. They are more strict in their being a vaccine mandate. Next slide, please. The other kind of set of laws that you may be thinking about related to this new OSHA guidance is your state laws or your state plans. So as Ron was explaining at the beginning, OSHA only covers states that are administered by federal OSHA. There are currently 22 states with approved state plans. For example, Washington, D.C. And New York are federal OSHA states. Maryland and Virginia have approved state plans. If you're in a state like Maryland or Virginia, you're going to be waiting for MOSH or VOSH to roll out their standard and not necessarily complying with the OSHA standard. The state plan standard has to be either identical to or at least as effective as the OSHA standard that was just announced. Those state plans have 30 days to come out with their state plan standard. And then employers will be required to comply on the timeline, set forth in whatever they come up with. So in some places, this probably clears up a lot of confusion. If you're in Texas or Florida, which are both federal OSHA states, where there are various state laws that have tried to make it more difficult to require vaccination for employees, OSHA's standard would preempt those state laws. You would need to comply with OSHA's rule. Things are a little bit more complicated if you're in a state plan state that is antagonistic towards the OSHA rules, such as Tennessee. You might have a longer wait and see period to see what the Tennessee Occupational Safety and Health Administration does in response to the OSHA rule. That might be a more kind of challenging wait and see situation. Go ahead to the next slide, please. So, what is the current status? As Ron mentioned, we're aware, and I think our invite mentioned this stay that was issued by the Court of Appeals for the Fifth Circuit. There are definitely a lot of legal challenges right now out there to this rule. The Fifth Circuit did issue that stay, so for the moment, the rule is on hold, but that could really change at any minute. What we expect to see happen with this is a bunch of lawsuits are going to be filed, and then they're going to be consolidated into one. Right now, we're aware of at least 12 lawsuits. I think like 3 more were filed this morning. This is going to end up proceeding under a multi-circuit procedure where they're asking right now, anyone who's going to file your lawsuit and get it in. They're going to hold a lottery sometime around November 16th that will determine which Circuit Court of Appeal is going to hear the case. If that Circuit Court of Appeal is not the Fifth Circuit, who has issued the stay currently, that circuit could review, revoke, extend the stay that the Fifth Circuit has issued. So it's possible that this case could be transferred somewhere, consolidated, transferred somewhere else, and that the rule will be back on in very short order. We just have to wait and see kind of how the case lottery works out. There are a lot of legal challenges being set up against the ETS. Kind of the main ones are that states are the only entities that can mandate vaccination, that the ETS exceeds OSHA's authority because there's no grave danger. The standard that Ron mentioned has to exist for OSHA to issue an emergency standard as opposed to a regular long-term standard. And that the ETS violates the Constitution and federal laws in other ways. The really important thing to know about these challenges is that we have no idea how they're going to turn out. We expect that a lot more cases will be filed between now and November 15th. We'll have a better idea about the timeline for how this is going to proceed after they're consolidated. But we do not have any real reasonable guesses about whether this standard will stick or whether or not it will be overturned. Just as a historical point, OSHA normally loses challenges to its emergency temporary rules. The last time this really came up was in 1983 for an asbestos standard. So it's really, who knows here on this one, which I know is not reassuring for anyone who's thinking about what to do. So what do you do with all of this? we would recommend you start preparing a vaccination policy and think about whether you want that to include testing and write one that would comply with this standard. As I just said, things are moving really quickly. Once the cases are consolidated, the stay could be lifted. There will likely be a fast track for review of this, and you don't want to be in a position where the stay is lifted, the rule goes into effect, and you're not prepared to deal with that. If the rule is knocked down, then you don't have to use the policy you write if you don't want to. But we would give some serious thought to how would you comply if the rule does go into effect. So that's the end of our prepared program. I'm going to kick it back to Ron, who will take some questions, and I know that we have a lot. So thank you guys for coming, and back to you, Ron.
Thanks, Robin, and thanks to all the attendees for so many good questions. Unfortunately, it's clear that we probably won't be able to get to all of them, but we'll try and get to as many as we can. I'm going to start by answering two, which relate to whether or not the ETS can be extended. The answer is no. That's consistent with the limited right to utilize that standard that was given to OSHA by Congress, because it is, in essence, a workaround for traditional due process notice and comment. The rule is quite strict that it can only be for 6 months, and the remedy for OSHA is to promulgate a new standard. And as you can see in ETS, they say that this is intended to serve as a basis for a broader, perhaps more permanent standard. And then the other question, which was related, that Robin just touched on a little bit, had to do with whether or not the stay affects the deadlines. Hard to say right now. It depends on how quickly it's resolved. It could affect them in a sense that none of the deadlines ever become effective, or it could be resolved such that the deadlines are not modified at all. So it's somewhere between yes and no. Let me switch real quick and ask Allison to address a couple questions having to do with the obligation to establish the vaccination status of employees who are only going to be remote employees or employees who are on leave.
Sure. So the frequently asked questions do not make a distinction between employees who are remote and employees who are in the work site. And so if you go by that exclusively, it actually indicates that you need to request vaccination status from all employees, regardless of whether or not they are remote, regardless of whether or not they would otherwise be covered. So that is something that you will have to collect unless we receive further guidance on it. For employees who are on leave or who may be on leave, the deadline to start collecting this vaccination status or to collect this vaccination status is 30 days from November 5th. And there is no exception for employees who are on leave or anything like that. And so it would be our recommendation that you do reach out to these employees and ask them for their vaccination status. Or if you are going to have a vaccination or testing requirement, at least send them the policy so that they understand that they need to either give you the vaccination status, or they understand that if they are going to report to work and choose the testing option, they will have to present a negative test before they report to work on the first day that they return. I wouldn't be concerned about any sort of about whether or not that's asking them to provide or to conduct work while they're on leave. I think that this is a pretty de minimis requirement on your part. So I don't think that it kind of interrupts or interferes with leave in any sort of significant way.
Terrific. Robin, we had a lot of questions about testing. And one question started with, can an employer set a higher burden, i.e. requiring all employees to be vaccinated, including remote employees, and concomitantly, if you have employees who are entitled to an exemption from vaccination under the Americans with Disabilities Act or Title VII based on religious reasons, would the employer in that sort of a scenario be required to pay for testing?
Sure. So you can definitely set a higher requirement. You can require all employees, including remote employees, to be vaccinated. That is the ETS specifically allows for that. So if you wanted to set a higher threshold for your workplace, that's absolutely allowed. As far as exemptions and payment, it's really such a fact-specific analysis. The easiest, not the easiest, but the least exposure, the least legal exposure that you probably have is by paying for the testing for those employees who have an exemption. If you wanted to explore other options, we'd encourage you to reach out to counsel, because this undue burden analysis is so fact-specific. It's going to be really hard to tell, is this one person an undue burden? If I have 10 people being tested under accommodations, is that an undue burden? There are just too many moving pieces to be able to say definitively for everybody. So I think those were the two, right, Ron? You had two parts.
Yep.
Great.
Allison, we had another question. What about employer-sponsored events off-site, not at the workplace, but say a holiday party at a local hotel? How does the ETS impact that?
Yeah, that's a great question. And the truth is that there is actually no answer for that within the standard or the frequently asked questions. But what I will say is we do have some ability to analogize based on kind of similar requirements under other related employment laws. And my perspective would be that those are extensions of the work site because they are workplace events. And therefore that requirement, for example, if you have an entirely remote workforce for right now, but you are having everybody come together for a holiday party, that this requirement to make sure that people are vaccinated and or provide testing, a negative test would apply in a situation like that as well, simply based on the way that other employment laws treat outside workplace events that are purely for work purposes.
Right. That's a particularly hard question, but if you draw analogies to workers' compensation, an event like that, which is designed indirectly, if not directly, to benefit the employer, would be considered in many cases or in many states to be compensable. So I think to some degree, it's going to depend on what someone's tolerance for risk might be. Another question, Allison, as long as I'm with you, is how does this rule apply to independent contractors, say subcontractors on a construction site? You have a general contractor who's got more than 100, but has a lot of subcontractors who are under 100. Does the ETS require the general contractor to impose rules on the subcontractors, or can it?
It does not require that. So independent contractors are not covered, and that independent contractors would include any subcontractors on the site. The subcontractors, to the extent that they are employees of other companies, may be covered by their own, their own employer, but they would not be covered by your rules. Now, that's not to say, again, as Robin has said before, that you could not require that other contractors on your site comply with similar rules, because that would be a stricter requirement than what the standard actually applies.
Ron, if I could jump in on to just extend that a little bit, especially if we're talking about the construction industry, you'll also want to consider whether you're subject to the requirements of the federal contractor rule. And if that's the case, that rule, differently than the OSHA rule, does require you to mandate vaccination among your subcontractors. So that's something that you would want to look at as well if you are subject to the federal contractor rule. That's a difference between it and the OSHA rule.
Right.
Yeah.
And of course, with contractors and other people who are working outside, you're going to need to take a look at the rule with respect to what does it mean to work outside exclusively. And it is fairly stringent. And the harder question is not with people who work outside, but when are they working in a structure that becomes substantially enclosed, so that it's considered to be indoors now and not outdoors. And that's going to require some degree of judgment. And I think what a lot of employers, particularly in the construction industry, are going to need to wait for is to see what the enforcement directive that OSHA is saying that it's going to publish very soon says. What they're saying is that they're not going to enforce this aggressively, that they're going to try and be more lenient and work with employers. But lots of times that message gets filtered out, and it's like the old game of telephone. What starts as green in Washington, D.C. ends up red the further away you get from Washington, D.C. So the issue is that, how will individual inspectors interpret their mandate, as it were, when it gets out to that area. Allison, I have another question here, which is, what about school coaches? And in particular, school coaches who may not be coaches on the effective date of the ETS?
Sure, that's a great question. So they are going to be considered employees, assuming that they get compensated for their work as coaches. And to the extent that they work exclusively outside, which I doubt that they do because they typically perform, I think, at least some of their work within an office or within the school building. But if they do work exclusively outside, they won't be covered. Now, the way that you count these employees is whether or not they are employed kind of as in terms of the number towards 100 is whether or not they were employed as of November 5th. However, if they're not employed as of November 5th, but they're employed later and the school is already covered because it already has over 100 employees, coaches would also be covered as an employee of the school, even if they were employed later on. And so you have to bring them up to compliance, meaning you'll have to collect their vaccination status and make sure or make sure that they comply with the testing requirements as soon as they're employed going forward.
Great. And alternatively, those spring sport coaches could take you from under 100 to over 100 and subject you to the coverage if you're not previously covered.
That's right. And then you will remain covered through the end of the standard.
There was another question about how records can be maintained, and the question was, would digital storage of vaccination records, attestations, etc., be acceptable, which is the word used in the standard? You want to answer that, Allison? Not really. Here, I'll give it to you.
Sure. The answer is that, yeah, there's nothing that says that these have to be hard copy records. And so digital records can be maintained. In fact, many of our clients actually have almost exclusively digital records as it relates to personnel. The question would be whether or not they are maintained properly. So the fact that they are digital doesn't absolve you of the requirements that they have to be kept confidential, separate from a personnel file, and secure, meaning that they're only accessed by a certain amount of people or certain types of people within your organization.
So another question that we got, and I'll start and then allow any of the three of you to add to it, is does this standard apply extraterritorially to employees who work overseas? And the answer, I think, is no. The jurisdictional limits of the Occupational Safety and Health Act are the United States and to the edge of its outer continental shelf. And typically, unlike some other federal laws, it does not travel internationally. That's only the beginning of the issue for employers, because you have to decide how many different policies you want to have, whether you want to have a separate rule in the United States than you do internationally. And in addition, you'll have to consider what, if any, rules the jurisdiction where your employees are working may have in effect. So you may be subject to much, much stricter rules in Canada or in France, for example, than you would be subjected to here in the United States. Allison, Robin, Julianne, anybody want to add anything to that?
My first thought when I saw that question was, is your international employee coming to the holiday party here stateside? Because that could bring them under the jurisdiction of OSHA if they're traveling here for a meeting or a party or any kind of event. You might want to consider at that point getting their status and treating them as covered under this rule.
Right. Well, I certainly think it would be prudent at a minimum to require testing before you, if you didn't know their status before you allowed them to participate. Robin and Allison, another individual asked, at what point in the recruitment process should an employer discuss the vaccine rule requirements with prospective employees or applicants?
I can start with that one. So a lot of folks I know are planning to put it in their job advertisement, basically just list it out this, you will need to be to show proof of vaccination, or to show proof of vaccination or an exemption, or to show proof of vaccination or testing or an exemption, depending on what your policy looks like, and just putting that in the job notice itself. At the very latest, you should have that conversation about getting their vaccination status or their exemption information at the point where you have extended an offer or a conditional offer of employment, because you want to make sure that they're going to both have time to comply, or that you have time to evaluate any exemptions and explain your policy to them before their first day of work. Allison, any other thoughts?
Nope, that was spot on.
Terrific. So I'm going to exercise my moderator privilege and cut things off now. I understand, although I have not been able to see them yet, that we have lots of questions that we just have not had an opportunity to get hold of. And I want to be sensitive to the time of everybody who is participating in this webinar. What I can tell you is that Robin, Juliana, Allison, and I will get a copy of all the questions that have been submitted, and we will either respond to the questioner, or we will put out something in a format that is available to all of the attendees, a document that identifies the questions and gives some answers. So we will try and do that in the next couple days, and hopefully everybody will get your questions answered. Again, as I mentioned at the outset, if you have any questions, feel free to reach out to any of us or anyone else within our group, and we will do whatever we can do to get the question to you. I want to thank everybody for their participation today. I think we've had really, really good questions. As is always the case, we attorneys sit and we try and think of these things, but we can never think of all of the real life episodes and events and questions that you come up with. And so as much as you think we're imparting to you, or at least I hope you think we're imparting to you, we learn a lot from this too that helps us in our representation, not only of you, but of all of our clients. So we want to thank you both for your participation, but also for your questions. And again, we look forward to getting back to those of you who have questions, or to answering questions for those of you who have not thought of the questions that you want to ask us. So let me wrap up by thanking Allison, Juliana, and Robin, who are really the people who pulled the laboring oars on this, but I really appreciate their gumption in getting this up and getting it going. And I hope that everybody has learned something and appreciates the information that we're able to give, even though there are so many questions yet to be addressed. Thank you so much.